So, what actually is the difference to me as a real estate agent when working with a public person, buyer or seller, as a customer versus a client? Have you ever asked yourself that? Well, today's video tip is going to go over the difference between working with the public person as a customer or as a client. Thank you so much for joining me. I'm Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. And just a brief video tip. I always say that. They always end up longer. But I just want to cover the difference between what it means in the contracts when you indicate that your broker, you via your broker, is working with a public buyer or seller as a customer versus a client. So the first thing to note is in both the Georgia Association of Realtors contracts and in the RE forms contract, there is a fill in the blank for you to indicate the brokerage relationship in the transaction. So it has brokerage relationship. Buyer's broker is, you fill in the company name. Seller's broker is, and you fill in the company name there. And it says is representing buyer or seller respectively as a customer, a client, a dual agent, or a designated agent. So what does that mean? And again, that is also in the RE forms contract. Also, just want to let you know that if you are an agent and you are helping a public person with a contract that's not on a GAR form or an RE form, it is a license law requirement that you indicate a brokerage relationship. In other words, if you are representing your public buyer or public seller as a client, you must indicate that in the offer. So GAR and RE forms have a fill in the blank if you're writing a new construction contract, HUD contract, so forth and so on, investor written contract, and that fill in the blank is not there. You need to add it to stay in compliance with license law. But what does all this mean? Well, basically, in Georgia, the client relationship is contractually driven. That means that a public person becomes a client of your broker by virtue of signing a brokerage agreement, a seller brokerage agreement for a seller and a buyer brokerage agreement for a buyer. There is also a tenant brokerage agreement and a landlord brokerage agreement. By default, if your public person does not sign one of those separate brokerage agreements, they are choosing to work with your brokerage and you as a customer. So what is the difference to you as an agent? What can you or cannot you do depending on that relationship? Well, if you do create an agency relationship by signing a brokerage agreement, I'll get into that in a second. Let me talk about if not. If you are working with a public person as a customer, then you can perform ministerial acts. And you have all heard that from pre-license, fiduciary responsibility versus ministerial acts. Well, what are ministerial acts and how do you know? Ministerial acts are defined in Georgia law. And let me just actually read the law to you and reference it so that you know where to find it yourself. So, in Georgia, under is license law OCGA 4341 5.1, it does define ministerial acts as those acts related to real estate brokerage activities which a licensee or licensee's employee performs and which do not require discretion or the exercise of the licensee's own judgment. This means that a licensee cannot provide opinions or advice to a customer. If a licensee does provide an opinion or give advice, he or she could unintentionally create an agency relationship. Then let's look to BRETA, the Brokerage Relationships Law in Georgia. It is Georgia Law 10-6A-3. We lovingly refer to this as BRETA. It is the Brokerage Relationships in Real Estate Transactions Act, also Georgia law. And it states that ministerial acts mean those acts described in Georgia Code Section 10-6A-14 and such other acts, and I'll get to those in a second, which again do not require the exercise of a broker or a broker's affiliated licensee professional judgment or skill. A transaction broker means a broker who has not entered into a client relationship with any of the parties to a particular real estate transaction and who performs only ministerial acts on behalf of one or more of the parties, but who is still paid valuable consideration by one or more of the parties to the transaction pursuant to a verbal or written agreement for performing those services. So the BRETA law goes on to further give some examples. So let me outline some of those examples here for you now. Ministerial acts. This is what you can do when working with a public person as a customer. You can identify property for sale or lease. You can provide them real estate statistics, information on the property. You can provide pre-printed real estate forms, contracts, leases. Now, as long as it's not a license violation, for example, GAR says you can't just hand a public person the GAR form, exhibits, but you can help them fill those out, so forth and so on. You can act as a scribe. You can, in other words, you can prepare real estate forms and contracts. You can help them with what has to be done to go about completing a transaction, such as locating architects, engineers, surveyors, inspectors, lenders, closing attorneys, insurance agents, and whatever other professional they need. You can help them identify schools, shopping, other facilities on behalf of any of the parties in the real estate transaction. BRETA goes on to say a broker acting as a transaction broker shall do the following. 1, timely present all offers to and from parties involving the sale, lease, or exchange of property. Timely account for all money and property received by the broker on behalf of a party in a real estate transaction, i.e. earnest money, security deposits. Timely disclose the following to all buyers and tenants: any adverse material effects pertaining to the physical property or any of the improvements, including but not limited to material defects of the property, things like environmental contamination, anything related to law or zoning or regulation. Disclose anything that you actually know or could not be discovered by reasonably diligent inspection of the property, i.e. latent material defects, and all material facts pertaining to existing adverse physical conditions of the immediate neighborhood within a mile of the property, which again you must actually know, in addition to anything regarding zoning, ordinances, land maps, so forth and so on. To further help you understand, you can also look at Georgia license law under GREC Rule 520-1-02 under the definitions, and Georgia license law through this GREC rule goes on to describe a customer, which again is just a person who has not entered into a brokerage agreement, meaning any public person you work with by default is a customer unless they sign a buyer brokerage agreement, seller brokerage agreement, tenant brokerage agreement, or landlord brokerage agreement. And a client is a public person who has signed one of those agreements. And discretion and judgment. Remember, it says you can't use your discretion or judgment. They're not objective. This is where we get a little bit vague, but basically that would involve an opinion or counsel or the benefit of your knowledge, your experience, your license, what you have learned as a licensed real estate agent. Discretion is actually defined as individual choice or judgment, the quality of showing discernment and good judgment, and judgment is defined as the process of forming an opinion or evaluation by discerning and comparing an opinion or estimate, so forth and formed. By default, working with a public person, they are a customer unless they sign a brokerage agreement. If they do sign a brokerage agreement, you must disclose that, and then you are working with them as a client, and they do get the full benefit of your knowledge, expertise, opinion, past history, experience, so forth and so on. You would address that in the contract. Now, you co-op agents, if you receive a purchase and sale agreement and it says that one broker is working with a public person as a customer, that still does not give you permission to what we used to say, cross assign. That still does not give you permission to contact that other broker's customer. That public customer has still chosen that brokerage with which to work, and you still must respect the professional relationship between agents and between brokers. So unless you have written permission by one broker to contact their client or customer, you still must go through the agents and through the brokers. The other thing that you need to pay attention to with respect to the contracts is regarding forms of notice. If you see on the front page that such and such company agent is working with a public buyer, public seller, landlord or tenant as a customer, the first thing you should do is flip to the signature page, because the notice section in the GAR form and the RE form state that notice to, if you're working with a client, if you're working with the public as a client, notice to the broker serves as notice to the client. There's a few more specifications depending on if it's a dual agency or designated agency situation. But generally speaking, notice to the broker serves as notice to the client. With a customer, however, you would still, as a courtesy, send notice to the broker that customer has chosen. But with respect to the contract, GAR and RE forms, you must also send notice to that customer. Meaning, on the signature page of your purchase and sale agreements, if a client relationship is indicated, then you only need the contact information, the email address, fax number, and or mailing address of the broker. If it says that the brokerage is working with the public person as a customer, then on the signature page, you need one of those three forms of ID, of contact, sorry, not ID. You need either that customer's mailing address, fax number, or email address in order to serve them with notice with respect to everything regarding notice in the contract. I'm going to link these laws below so you can look them up for yourself. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, director of the Real Estate Academy of America, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.